All right. Hello, everyone. We're just letting the attendee list get in. We'll start in just a second. This is a pretty big topic, so we still have a lot of people spilling in. So as soon as the numbers stop climbing so quickly, we'll get started.
How dare you, Randy? I'm trying to be respectful for the new host. This is Isaac's first big webinar. So, wanted to give him a chance to ease into it before I do what I do.
If I'm on enough of these, it would be an interesting competition to see who could talk longer. That's usually a trick getting me to shut up. Thank you, Randy.
Obviously, you've never seen me on one of these webinars. Wow, 360. These numbers are just climbing. I love you, CCPA World. Like we put out this alert, like the link went out on Sunday, and here we are 2 days later, and we've got 400 people listening in. I love that, man. So the good community, people who really care, want to do things right, want to understand and have information, and I love it. And I can't wait for the regulators to meet all of you, which is probably going to happen soon.
Hopefully under friendly terms. But yeah, that number is still climbing. So I'm gonna give it just a couple more minutes. I don't want to lose too much time waiting for everybody to get in, but obviously the platform is going to let people in as quickly as it can.
The natives are restless, man.
Yeah, it's kicking off. So
all right, here we go.
Yeah, I'll go ahead and get started. So for those of you still getting in, welcome. But for everybody else, good morning or afternoon, depending on where you're at. I'm a new face here at Contact Center Compliance. A lot of you probably know me from the industry already, but my name is Isaac Schloss, and I am the Chief Product Officer here at Contact Center Compliance. If any of you are not familiar with us, Contact Center Compliance partners with our customers in complying with many of the regulations regarding customer or member outreach. So this includes scrubbing numbers against state and federal do not call lists, number reassignment flagging, weeding out known professional plaintiffs from the list using our litigator scrub, and some other services like that. We also go a step further by helping with final call delivery through our remediation and call branding services. We don't just monitor your call ID reputation, but we automatically work to pull customers off the list that show them as potential spam. And even if desired, we implement a branded text display on outbound calls, trying to restore customer trust in calling as well as maximize contact rates. So as a quick housekeeping note, we have a Q&A tab here. So viewers, please post your comments or questions there. I'll try to watch the chat tab as well if that's been enabled. We'll do our best to address all questions during this call, but if we run out of time, as we often do, I assure you we will follow up over the next day or two. So all that said, this has already been an interesting year from a legislative and enforcement perspective. We've seen Maryland looking to adopt Florida's automated dialer definition rules, Florida potentially looking to adopt the TCPAs, and the FCC essentially shutting down a dialer company under what I personally believe to be questionable circumstances. And we're only 2 months in. Last week, the FCC published their notice of proposed rulemaking, and the implications on the marketing industry as a whole are quite serious. So in today's webinar, we're going to present an overview of that notice and what that can mean for us all. Now, clearly, there's a lot of interest for this. We've had over 700 people sign up for this so far, and people are still spilling in. So I'm very excited to get started and introduce our guest speaker, who really needs very little introduction, Eric Troutman. Known simply as the Czar in certain legal circles, attorney Eric J. Troutman is one of the country's prominent class action defense lawyers and a renowned thought leader and speaker. A gifted strategist and world-class courtroom advocate, the Czar is trusted by many of the nation's biggest companies to handle their toughest multi-billion-dollar exposure cases. The Czar has served as lead counsel in hundreds of putative nationwide class actions and successfully navigated thousands of individual litigation matters. He is well known for finding creative solutions to complex legal problems and has earned numerous first-in-the-nation results and precedent-setting cases for his clients, all while having plenty of fun along the way. So with that, Czar, the virtual floor is yours.
Well, I appreciate it. Hi, everybody. Hopefully you can see me. I can't see myself on the screen, but I'm going to assume that you're all looking at me. So look, let me start by first telling you all, I love you. Thanks for being here. Hundreds of you showed up like that, 48 hours notice. I love it. What a responsive, wonderful TCPA world we have. I'm going to start, as you all would expect me to, by saying, I told you so. You might remember back in December when Public Knowledge first filed its comment in response to the assurance petition in December. I was all over it. I pulled it, I saw it, I put it up on TCPA World. I said, alert, guys, this is a huge, huge deal. And sure enough, here we are a couple months later, and the FCC has issued an NPRM on this issue that Public Knowledge has raised. And we're going to break it down. We're going to get into really nitty-gritty detail here. I know you've got a lot of questions, but let me start with just a couple of kind of high-level things for you guys to keep in mind. First, what is an NPRM, and what is the FCC, and what does it have to do with anything? All right, so all the way back, first principles, we know that the TCPA, right, the Telephone Consumer Protection Act, right, which is the crown jewel of the federal response to the robocall epidemic, that says thou shalt not make certain phone calls without express written consent, right? We know that. So what the FCC is doing right now is looking at the contours of express written consent. When is consent valid? When is it not valid at the highest level? And the FCC is empowered by Congress to implement the TCPA by issuing certain rulings from time to time that can clarify certain provisions within the TCPA, such as the phrase express written consent. So the FCC has this power, all right? And the way that it uses this power is through something called a notice of proposed rulemaking, which is a requirement under something called the Administrative Procedures Act here in America, the APA. Under the APA, before a regulatory institution like the FCC can issue a new legislative rule, it has to first give notice to everybody and seek comment. The comment period, which we're going to talk about right now, is your chance, your one and only chance to weigh in on what the FCC is proposing to do, which, as we're about to see, is a really, really big deal. If you are impacted by this ruling, and most of you are going to be, I highly encourage you to either in your own name or through part of a trade organization like REACH, which you're going to hear a whole bunch about today, to get out there and comment to the commission, and to, beyond just putting it in paper, right? If this is going to hurt your business substantially, like put you out of business, like it's going to for a lot of people, like thousands of companies will be put out of business by this ruling. This is why you're all listening in very carefully. I encourage you to hop on a plane. We can help facilitate the meetings, get out to the FCC, meet eyeball to eyeball with these folks and talk to them. In fact, the head of policy for the Consumer and Governmental Affairs Bureau, which is the very bureau that is going to be putting out this proposed ruling, will be joining me on stage, and Ronnie Allen from CCC, at LeadsCon in Las Vegas, right, on the 15th of March. So if you happen to be in Vegas, you want to come out and see someone from the FCC who's very, very much involved with this notice of proposed rulemaking, I believe, come on down and, at least say hi from the stage. But in order to actually impact this ruling and have a conversation with the commission, you actually have to fly out to DC, have meetings, and then do something that's called an ex-parte. We'll talk about all of that. I just want to kind of level set so you understand the groundwork. Now, the second big question that I'm getting right now is, what the heck is public knowledge, and why does the FCC care so much what public knowledge is suggesting? Well, hopefully all of you know there are 5 commissioners at the FCC. 3 of them are appointed by the governing party, and 2 of them are the opposing party. So for instance, right now, 5 commissioners, 3 of them are supposed to be Democrats, 2 of them are supposed to be Republicans. I say supposed to be because although there are 5 seats for commissioners, right now there are only 4 that are currently filled, 2 Democrats, 2 Republicans. The 5th is not yet confirmed, a lady named Gigi Sohn, who was recommended by President Biden, who was the co-founder of, guess what? Public Knowledge. All right, so this is a very, very connected organization. This particular FCC, which is currently the chairwoman is Jessica Rosenworcel, who is very consumer friendly. It's not necessarily a bad thing, but she's just very consumer friendly. And organizations like the National Consumer Law Center, the NCLC, who pretends to be pro-consumer, but really is pro the plaintiff's bar, is in the FCC constantly filling their ears and their heads with all kinds of stuff about, robocallers and the TCPA and the need for more lawsuits and goofy stuff like that. Public Knowledge is a horse of a different color. They're a little bit more kind of intellectual, shall we say. They're a little bit less kind of in the pockets of the plaintiff lawyer. They are viewed, I think, incredibly favorably throughout the Beltway, although also still certainly consumer leaning in many ways. So when Public Knowledge came to the commission back in December and said, hey, we want you to hold that in order that consent has to be provided directly from a consumer to a product seller with no intermediary, I knew that was a massive shot across the bow of the lead generation industry. And for those of you that follow TCPA World, I did a big report on that. I jumped on with Mike Faree from Lead Generation World to talk about the impact. I talked about it on stage at LGW. I was planning to talk about it again on stage at LeadsCon, but now I don't have to because, of course, we're going to be talking about it right now. So backing up, or actually moving forward, what Public Knowledge has basically told the commission is the lead generation industry is a real problem. There's a ton of fraud and there's a ton of abuses. And again, it's not my opinion. This is what Public Knowledge and others are telling the FCC right now. And to date, the FCC has heard nothing but this, right? The lead generation is full of fraud. It's full of abuse where a consumer provides, their consent on one website. And then that website then, sells it to an aggregator who sells it to 6 other aggregators who sell it to 6 other aggregators who sell it to, who knows where, and that's just in real time. So you might have 100 companies that buy the same lead within, say, a 15-day period. Each one of those companies, of course, making, some inordinate number of phone calls. So one consumer can provide a consent on one website one time and receive thousands of phone calls. And that's not even counting aged leads, right? That's just talking about real-time leads. And although the scenario I just gave is fairly abusive and probably not the norm, I think the norm is that a lead might be sold considerably less than, say, 5, 10, or 20 times. Those of you watching this in the lead gen industry know this does happen, right? That is reality. What Public Knowledge and others are sharing with the FCC, although it is, perhaps edge cases, it's not a false narrative that's being spun. They're just focusing on the abusive cases. What the commission has not yet heard, of course, is the story of the benefit that the lead generation industry provides and that marketers more broadly provide. And we'll talk through kind of what you can do to help educate the commission. So what has actually happened? Let's talk about what has occurred so far. So the commission issued a ruling last week on, was it Friday? God. In which the commission made a couple of findings. First, it issued a final ruling that now requires the creation of something called a do not originate list, which we'll talk about here in a few minutes, which is going to be populated in a, quote, reasonable way, in which should, in theory, if it works the right way, and I know Dave Frankel is watching this webinar. Hey, David. He tells me it's gonna work okay. It's not going to be abusive. It's not going to be something where everybody's number gets put on the list and no one can communicate anymore. But there's going to be a do not originate list that should only have phone numbers that are disconnected or phone numbers from real companies that are being misused so that we can stop certain spam messaging. Assuming the DNO process works appropriately, that component of the ruling, which is a final ruling, by the way, that's not part of the NPRM, that is a final ruling from the commission. I can live with all of that, assuming it's not exploited and misused. We'll talk about the ramifications of that in a second. In addition to that ruling, which has been made, there was an NPRM, which is a notice of proposed rulemaking. Now, the timing here is a little unclear. We'll talk about that in a second, but the notice proposed ruling has three components. One component is that the commission is proposing to expand its power to command the carriers to stop connecting messages from just calls to also to text messages. So right now, as you probably know, and Isaac referenced it, for instance, just last month, there was an order that came down from the FCC directing every carrier in the country to stop carrying the traffic of MV Realty as it went through the phone burner platform. The carriers misunderstood the ruling, which was, frankly, a catastrophic issue for phone burner, and they were shut down for 2 days because no carrier would touch their traffic because of the FCC shutdown order. The FCC did not intend to shut down phone burner completely, just that one little pocket of potentially fraudulent traffic coming from MV Realty. Nonetheless, the carriers responded very aggressively and shut down so much traffic. So that the power that the FCC has over voice channel communication, it does not yet have over text message communication. And the first part of the NPRM would be to give the FCC the power to order shutdowns of text messaging in addition to voice channel communication. Ramifications there we can talk about. The second piece is that the FCC wants to expand the protections of the National Do Not Call list to text messaging explicitly. Now, most of you are thinking, what are you talking about? The TCPA and the DMC rules already apply to text messages. True, probably. But the FCC has said, look, we've never expressly said that, so I think we're going to now expand it explicitly. So we want to get comment on whether or not we should or shouldn't do that. That's actually an opportunity to those in active litigation involving text messages on the DMC list. We can talk about that separately. The third component of the NPRM is the thing that we really need to be paying attention to. It is a massive, massive potential shift in the law, and one that would be crippling to thousands of businesses, and really, will have unintended consequences that will ripple through the entire American cyber economy. So it's a really big deal. And it is, and there's different pieces to it. And unfortunately, the FCC has kind of buried the lead. All right. So there's a few pieces to it. And if you start reading the section of the NPRM that they're calling closing the lead generation loophole, you see where this is going, guys. A couple of things they're looking at. First, right, they're looking at saying multi-vertical consents are gone. Right, meaning you go onto a website regarding home insurance, or sorry, let's say, we'll pick on realtor.com. You go on realtor.com because you're interested in getting an agent who can show you a house that you're interested in. And down below in the little fine print, right, you're getting consent to also, sell that lead to mortgage companies for lending purposes to call regarding lending, or to a solar company to call regarding the solar panel. If this new NPRM passes, those kinds of multi-vertical lead websites would no longer be valid. Realtor.com could only provide leads to real estate agents, not to lenders, not to solar companies, okay, as an example. That's one. Two, the NPRM suggests that the FCC is highly skeptical of hyperlinks that link to large numbers of marketing partners. Now, the language here is a little vague. I think this is overall kind of thematically that the commission is not entirely sure where it's going with a lot of this. I think it senses that there's something wrong with hyperlinks, but it's not entirely sure what it wants to do with it, which is why it's seeking comment to see what the rules should look like. But at a high level, the commission is suggesting that you can no longer have a hyperlink in a marketing partner page, but you must actually just have everybody specifically identified that in the disclosure to whom a lead might be sold or disclosure might be sold. I've got some thoughts there. We can unpackage them. But third and finally, and most importantly, as I've talked through all of these things, now we get to the real meat. And I led with it at the beginning of this, which is the commission seeks comment on public knowledge's request that essentially there can be no intermediary between the consumer who provides consent and the ultimate product or service provider who can make phone calls as the direct consumer marketer. That means that we draw a complete line from the consumer just to the direct consumer marketer. So we'll pick on, let's say, Mutual of Omaha. I don't know why of all the companies in the world I pick them right now. I love Mutual of Omaha. Let's say, a customer wants to get a mortgage from Mutual of Omaha. They cannot go onto, let's just pick on LendingTree and provide information on LendingTree, which is then sold to Mutual of Omaha. If this new NPRM passes as suggested, i.e. that the public knowledge request is adopted, LendingTree is dead. It no longer exists. The consumer has to go directly to the Mutual of Omaha website and provide the consent only to Mutual of Omaha. Now, many of you clever individuals are thinking, aha, that is an opportunity for me as an affiliate to drive a bunch of traffic to Mutual of Omaha and get clicks, and I'll get paid that way instead. Maybe. And that is just one of millions of unintended consequences that this ruling might potentially have. And we all know how the affiliate space works and how much worse actually it could become for consumers if they can no longer go to a nice reputable website like lendingtree.com and instead have to deal with the mess of affiliate tracking URLs and reconnects that you see sometimes with the tiny URLs and the text messages sent out by affiliates. We know how nasty that business can be. So anyway, point is, currently, right now, the punchline, Commission is considering saying there can be no intermediaries, no data leads, no warm transfers, phone connections. The consents can only go from the consumer directly to the direct consumer marketer who's providing the good or service. Period, full stop. Let me pause to take a breath. Isaac, what do you think?
Well, I just had an interesting question that came up here, and somebody was asking, what if they're dynamically populating from a list of multiple brands? So, I'm a LendingTree, just as an example, and that, I'm putting this into the anonymous question here, but I'm a LendingTree, and I say, okay, well, you know what, you're going to be contacted. Now, I realize there's the direct aspect, so let's put that aside for a second. And just talk about disclosing who you're going to sell their information to. If you say, hey, I'm going to sell to brand A, brand B, brand C, these are the three potential lenders that'll be contacting you, that would still fit the model of at least disclosing exactly who you could sell their information to, correct?
So again, we have to break it down, right? We're gonna do it in the reverse waterfall that I just gave you. If the public knowledge proposal is adopted, the answer is no. That scenario is dead. You cannot sell the lead. It cannot be sold because it is not valid express written consent unless it is provided directly to the caller in the first instance, right? Not just the caller, but the service provider. So lead generation is dead at the highest level. All right. Now, if the public knowledge proposal is rejected, and understand the commission is looking for middle ground here, right? And that is the nice thing, I guess, something I should have emphasized. Unlike most NPRMs, where the ruling is essentially baked, right? Here's what we're going to do, but we're seeking comment. This one's a little bit different. The commission has basically said, we recognize that there might be some value to comparison shopping. We recognize that there might be some value to lead generation, but we're seeing a whole lot of problems, and public knowledge is saying we should just get rid of it completely. So is there some kind of middle ground, right? They're kind of really opening the doors to folks to come forward and give proposals. So for instance, the example that you just gave, well, what about, FCC, instead of saying you can't ever have an intermediary, what about you have a limited number of partners that populate on a dynamic disclosure so the consumer knows in real time before they click the button exactly who that lead could be sold to? How about that, FCC? I think the FCC might like that, right? That's a great example. And of course, REACH, right, Responsible Enterprises Against Consumer Harassment, big trade organization of lead buyers and lead sellers, has a set of standards that, in fact, do require the publisher to disclose to the consumer, right, on that website in plain black and white, how many times, for instance, that lead might be sold, how many entities might be making phone calls to you, and who those entities are. That is exactly consistent with the REACH standards, which, again, jumping to the punchline, my current plan, and we're here to talk about this, right? This is an industry issue. It's not just the czar is going to go out and solve it on his own. We all have to kind of weigh in on this. But my current plan is to take those standards, right? Those middle ground standards, go to the commission and basically say, look, guys, you're right. FCC, you are correct that the lead generation industry has caused a lot of problems. And if anyone is not willing to admit that, you're not going to have credibility with this commission, because that is just a fact. There's been fraud and there's been abuse. There just has been. That being said, the lead generation industry delivers value. It helps people. It is good for information and for engagement. It is not a bad thing per se. And comparison shopping is extremely valuable. And the lead generation industry and performance marketers enable and empower consumers from that perspective. So when it's done right, it's a fabulous thing. When it's done wrong, it's a horrible thing. And the commission has been living in the world of it's horrible for so long that something drastic is about to happen. But again, gratefully, they're looking for something in between. They're looking for that middle ground. They're looking for those suggestions. So the REACH standards, I believe, are one, perhaps not the only, but one very clear middle ground set of standards that lead generators will give them a little bit of breathing room, right? It'll let the industry continue to evolve and live, I think, in a sustainable way without all the harassment that we're seeing right now arising mostly out of fraud, but also out of, some highly questionable practices with regards to the number of times that leads are being sold. So that was a suggestion that you just received that I think is a good suggestion and something that should be presented to the commission. And again, if your company wants something like that specifically presented to the commission, hey, don't shut us down. Instead of doing that, allow us to just present at 5, right, to consumers. I think the commission would respond favorably to that. Where exactly that line is going to be drawn, I don't know yet, right? But this is exactly the kind of record that the commission needs to see so that it makes a smart decision, an informed decision.
Okay. And we do have a comment in here from David Frankel, and I'm only mentioning by name because you called him out at the beginning. You mentioned him a couple of your articles, but lendingtree.com, he says, wouldn't be out of business. They just have to have a more consumer-friendly way to connect with prospects versus massive outbound calling, like sending emails and providing a call-in capability for the consumer. Yes.
The business model as it currently exists would no longer exist. But David Frankel is not wrong that, LendingTree and others, you're creative folks, you'll come up with something totally new, you'll find a way to survive, is at least what I think the consumer bar is hoping to tell the commission. I'm not so sure. LendingTree's model is we generate data leads and we provide them to wholesale direct-to-consumer marketers. That is their fundamental model. Now, obviously, LendingTree and its counsel can speak better to the chances of its survival. But my point is not that LendingTree is going to go out of business. My point is that the model that the lead generation industry has grown up with is about to be stripped away, potentially completely, but certainly it's got to evolve and mature if it's going to survive. And it has to happen now.
And not to hop on the soapbox with you about ethical practices and whatnot, but I think what you mentioned a few minutes ago is absolutely right. A lot of this comes down to the fact that there have been many bad actors in the space that have created a bad label for everybody operating in the industry. So I think that it's important that sooner rather than later, we start adopting practices, self-regulating ourselves to try to maintain some sort of reputation, and obviously commenting and getting involved with this. I don't want to get held up too much here, but I'll throw a couple more questions and let you continue. Going back to what you had said about affiliates, there's a question where it's specifically asked, so if a company has affiliates, how will this impact that? Can a company share a customer's data with affiliates?
So currently, this is not a data sale, data transfer issue. This is an extent of express written consent issue. So affiliates, and we all know affiliates do a lot of different things. When I referenced affiliates, I was referring to affiliates who are driving site and selling clicks, essentially, or driving the site. And we know that many times when you're doing drive to site campaigns, there's fraud even there too, right? And there can be, front end outbound that lead to inbound, or front end outbound that lead to clicks campaigns that are just as abusive, if not more abusive, than your traditional outbounding that takes place in connection with regular data leads or warm transfers. But kind of more broadly, to the extent the question is, can we still work with affiliates on warm transfers or data leads? No, the answer is no, right? Again, if the public knowledge approach is adopted, and again, we have to just keep going through the striations because, the public knowledge approach is lead gen is dead. Do I believe the commission will go there? I do believe that if industry does not speak up. again, public knowledge is very powerful. The MCLC is very powerful. You guys are playing against a stacked deck. You have to understand that. These consumer groups are in with the commission all the time. And that's not to say that, you know, the FCC will just turn over and do whatever the MCLC says, but man, they might, you know, I mean, you can't rule that out. Now, the way that you avoid that is, again, industry pushing really hard and saying, no, here's the value, here's what will happen, here's a middle ground, blah, 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 blah. Okay, so that's the worst case scenario. Middle case, right, is, or one of the middle cases is hyperlinks kind of go away. Well, if you're an affiliate, right, and you know you work with 100 aggregators and they work with 6,200, you know, potential service providers, and you want to have them all listed on your disclosure, well, that's not happening anymore, right? That's gone. So there's going to be, in all likelihood, you know, no matter what happens, there's going to be a massive shakeup. You know, there's going to be far fewer aggregators, in my opinion. There's going to be far fewer affiliates. There's going to be far fewer publishers, right? There's going to be a large effort to consolidate in the industry. It's just going to be necessary no matter what happens out of this, right? That's what I'm saying. Like, understand, even if we can avoid a worst case scenario for the industry, things are going to change. This is going to be a sea change when the NPRM, whatever it finally looks like, is finally adopted. And of course, you know, that at the very bottom that we've been talking about, related but a little bit different, is, you know, the multi-vertical pages, right? You bring the consumer on for one reason, and in the fine print, you have tossed in a bunch of other stuff. That practice is dead. Like that, Reach is not going to defend it. Reach is going to say, good, FCC, we support that, right? So those of you that you know have, you know, I'm sure nobody watching this does this, because these are the compliant folks that do it the right way. But you all know who I'm talking about. There's plenty of folks out there, publishers and others, who think it's perfectly cool to bring the consumer onto the website to, you know, get a Walmart gift card or to do, you know, something else, and then they just kind of stick in those disclosures and, you know, try to sell it off. And I love you, Jernaya. I love you, Trusted Forum. You know I love you guys, but you know those certifications, those certificates sitting there capturing just the disclosure, just the consumer clicking the button, right? It misses the bigger picture. And that's not to say that those tools can't help you to see the bigger picture, but unless you as a lead buyer are looking at the overall flow, you might never even know that this consumer was there to look at, you know, circular saws and end up agreeing to auto insurance, right? All you see is that disclosure that looks clean from a Jernaya perspective or a Trusted Forum perspective. And that, I'm telling you, that practice is dead. Like, that practice is gone. There's no way the commission is going to allow that to continue. And in my opinion, good riddance.
Now, okay, so I'm gonna use something I hear you say all the time. In fact, you know, and this question came up earlier. This recording will be posted on dnc.com/webinars. You can watch it after the fact. If you go back and do what I did when I joined the company a couple months ago, you can watch all of our webinars going back several years. So, you know, something I've heard you say quite often is consent, 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 consent. So let's say, you know, we're talking about the no warm transfer option. Let's say I'm on the phone with someone, I'm an agent, and somebody's just signed up with me for, you know, I created the lead, I called them, I sold them auto insurance, and I say, hey, we partner with an organization that does home lending. Would you like to talk to them? If the customer consents to that, would I be allowed to do that type of warm transfer in that scenario? Because that is still a separate vertical to an extent.
Well, I mean, look, so that's an issue to begin with, right? Let's throw away everything that the FCC is considering and just talk about that scenario under existing law. The oral referral is a problem right out of the gate, right? Because if the company is not named in the original disclosure, then that call might have been made for a dual purpose. One purpose was whatever the consumer consented to. The second purpose was to try to sell a referral to somebody else. But the consumer is only giving you consent for the one purpose and not the other. So right away, boom, that call's illegal. Then when you transfer it to that person or that company that just wanted a valid referral, well, now they're pregnant with the call too, right? And you could argue that the call was made on their behalf. So now they are potentially at issue because your call exceeded the scope of consent to begin with. So that practice isn't legal, in my opinion, in most circumstances. There are exceptions. In most circumstances, that practice isn't legal today. So it's certainly not going to be legal once the commission gets a hold of you know, the new express written consent rules.
All right, I'll go through one more question, then I'll let you move on here. And I think I know the answer to this one, but if you're operating your own business, you capture express written consent on your own website. So there's no lead generator, no third parties involved. but you have a family of companies that you own and operate, and they're in different verticals. The question posted is, can you no longer include those family of companies in your express written consent language? And my guess would be you cannot, because that would still make it a multi-vertical lead, correct?
Correct. And again, even today, right, that is a suspect practice. Understand if you, family of companies, let's say, geez, who do I pick on now? Let's say, you're Coca-Cola and you've got a Dasani, you go to Dasani.com, you provide consent to hear about Dasani offers, and all of a sudden, you start getting Chobani offers, also a Coke, product. Arguably, hey, it's still a consumer good being offered by the same company. What's the big deal? Okay, that's one argument. I could see a court saying, depending on what the disclosure says, what the consumer's website experience was, that the consumer's reasonable expectation, which is the test, even under today's law, was defeated, and the consumer thought they were going to only receive one thing and not a whole bunch of other things. So again, I'm not telling you that your multi-vertical disclosure that within a family of companies is illegal. I'm not saying that. I'm saying there's already risk today. Just keep that in mind. And based on what the NPRM is considering, again, I think most courts and the commission in particular like to look at things holistically and from the consumer's perspective. So I could imagine a website that was like, welcome to the Coca-Cola family of companies. By clicking here, you're going to get information about all of our stuff. That would be fine. Versus, by clicking here, you're going to find out about Sprite, right? But then it's only Sprite. It's not all the other things. I know this is probably not the best analogy, but hopefully you're deriving you're seeing my point, which is, post NPRM, I think there's going to still be a little bit of gray, and there's still going to be a little bit of play, especially where you've got related companies involved and related products and services. But the hallmark is going to be more than ever before, transparency, transparency, transparency. And if that consumer knows what they're signing up for, even if what they're signing up for happens to be kind of multi-vertical because this company offers lots of products and services, that's probably going to be okay. Again, we have to wait to see what the language actually is. That's probably going to be okay. But if you're trying to kind of get the consumer, laser focused on one thing, and then you want to try to cross-market them, that's probably not going to be okay, even if you're related companies.
Okay. Well, there's a few more questions in here. I'll go through and gather a little bit more if you want to move on.
Yes. So let's talk about kind of timing and next steps. So this is, it's a little bit of a weird ruling. Usually when the commission issues an NPRM, there is a set comment date. I've been talking with some friends and kind of, I think the viewpoint is that what is likely to happen is that the commission is going to quote unquote consider the NPRM at their March 16 open meeting, which I encourage you folks to attend if you'd like to just kind of watch. It's not like a, hey, let me ask you a question kind of meeting. It's just a watch meeting. The commission is going to consider, the four commissioners are going to consider the NPRM at that meeting. What we believe is likely to happen is that at that point, the NPRM will be accepted for release, formal release. It will be registered in the Federal Register, and everyone will have 30 days to do a comment. Now, it is not clearly stated in the NPRM that that is going to be the procedure. And with love to the folks in the Biden administration, we have seen recently some of these agencies run a little roughshod over the APA and over other kind of procedural protections. So I am not 100% convinced that they won't do something crazy and adopt a rule at the open meeting. I know, there might be a staffer from the commission on right now going, oh, Trotman, we would never do that. Okay, I mean, probably, but look, I'm a guy who operates under like abundance of caution at all times. So Reach will be submitting a comment by March 9th on this. I think I've talked with the head of PACE. I believe PACE will be doing the same thing. I believe Consumer Consent will be doing the same thing. I think there will be a number of trade organizations that want to get out, ahead of the open meeting, put their foot in the door and say, commission, we're looking forward to an opportunity to provide more and deeper comments. But right now, you just have to understand, right, this public knowledge proposal is a really big deal. Please don't do this to us. There's middle ground. There's better position. But the way it should work, right, is March 16 open meeting. Let's say March 17, it goes into the Federal Registrar. You have until, let's say, April 16, April 17 to submit a comment. So a lot of you folks might be thinking, well, how do I submit a comment? Easy enough to do. You can do it on the FCC website. We can help you if you want, legal support. There's lots of lawyers that can help you to do this, or you can just do it yourself. right? That's one of the nice things about the FCC comment procedure is it doesn't have to be super formal. Of course, we draft formal things that point to a bunch of case law and legal issues and kind of break them down for the commission because that is required and necessary for the commission to really consider industry's position as a whole. But anecdotes, concerns about your business, concerns about the impact this will have on consumers, that doesn't have to come from fancy lawyers. It doesn't have to come from fancy trade organizations. It can come from you. And in fact, from a certain perspective, the commission really looks to hear directly from participants in industry, people who these rulings will directly harm. So I encourage all of you, once this thing is formalized, crystalline, and there's a comment period, to submit comments. And for those of you who are really concerned, like your business model's at stake, your livelihood's at stake, reach out to me, right? Not only can we help you with the comment, but we can get out there with the commission and have eyeball to eyeball meetings. And that is something that's gonna be really important for folks in this industry. And just, again, I can't emphasize enough, day in, day out, right? The commission meets with certain not trade organizations, frankly, special interest groups, right? That are filling their head with consumers are angry, robocalls are blasting people. And of course, you don't even need to hear that from an organization. Everyone knows that, right? The robocall epidemic speaks for itself from a certain perspective, and the FCC believes it has to do something. So if you don't want the hammer drop on the industry, you've got to get out there and say, industry is going to do something. Like we've got this. Like we understand it's a problem. We're going to help. We're going to offer you a middle ground. We're going to do something, and then help the commission understand why it's complete proposal to knock out the industry is not the correct answer. There's a better middle ground.
Now, once these rulings, once this is published and they start seeking comments, what is the comment period? It's 30 days, isn't it?
It is 30 days.
Okay, that was one of the questions that was put on here. Now, obviously, people are going to want to know where they can see the published ruling and how they can keep up with that. Suggestions for them, obviously, TCPAworld.com. I'm sure there'll be 1 or 2 articles posted on that.
One or two.
1 or 2. Any other ways you would recommend people, keep up with this?
Well, they can attend the open meeting. TCPA World, of course, is, I think, the best way, in my opinion. I'm not just saying that to self-promote. I mean, you guys know we pour tremendous resources into breaking this stuff down, being on top of it, and keeping everyone in the loop. You can also follow, basic things. Follow the FCC's Twitter account. Follow the FCC's LinkedIn. They're pretty active. They issue press releases. Or just have David Frankel be your buddy like I do, and then you'll just get regular updates on the back end stuff. But in seriousness, look, CCPA World is like it's magic for you guys because, as you know, I've got lots of little birdies who like to sing to me, and I can't always tell you everything that I know, but I can tell you a lot, and I tell you as much as I possibly can. And many times I know way before something's going to happen, right? Like that's kind of the magic things about being me. And again, I can't always tell you everything, but I will always do my best to leave a trail of breadcrumbs so that no one gets hammered without having some ability to react ahead of time. So there you go.
What if you were asked the question if there would be any implications this would have on cold calling or texting for the real estate market trying to generate leads? Now, obviously, this would have implications on their ability to purchase leads, depending on how they go about getting their leads. But as far as working off a list or trying to create a list on their own to call leads, do you see any problems with that?
Well, see, this is the dark irony of what the commission is doing by torpedoing express written consent and making it more challenging for companies to do it the right way. They're essentially creating a new environment where only people doing it the wrong way are going to be able to prosper. Folks that are doing cold calling, especially like these individual agents, 92% of what they're doing is illegal, but they just keep doing it anyway because, well, most of the time they don't know about it. And, to the extent it's just like one little agent out there trying to work their neighborhood to get some sales, maybe they can't be faulted from a moral sense of just trying to reach out to their neighbors and make phone calls. But the truth is, if you're cold calling members on the DNC, that's illegal. It's always been illegal. It's always going to be illegal. But this ruling would not impact that set of laws, except that it would more expressly confirm that text messages are also subject to DMC protections.
Okay.
And by the way, this is the first time I've ever been on a webinar and seen the question and answer go over 100. There's 99 plus questions that are currently pending, Isaac. Let's go, man. Let's try to get through some of these. I've never seen that. That's wild.
So interestingly, some of the comments and questions are spam, so I think there's a little bit of fun there going on. Do you feel the proposed FCC regulations may be related to the 2024 proposed CMS regs about lead gen and TPMO TPMO data?
Sorry, I missed that. I was looking through some of the spam. There is some spam in there. You guys are jerks. We're trying to do the right thing here. Behave. All right, go ahead.
Do you feel the proposed FCC regs may be related to the 2024 proposed CMS regulations about lead gen and TPMO to TPMO data?
Yes and no. So at the highest level, they're related because both agencies are getting a bunch of complaints about the lead gen industry, right? So there is a relationship there, but this is, to me, it just kind of shows you the stunning disconnect between different hands of the government. And we've seen this before with the FTC and the FCC going in completely different directions on things. And so here we see it again. CMS, right, has basically said you can't sell lead from one lead provider to another using shorthand. TPMOs can't sell beneficiary information to another TPMO, right? That is different fundamentally than the FCC's proposal, which is not limited to lead generators selling to aggregators. It's basically saying the consumer has to deal only with the direct seller, not lead seller here, seller of the good or service that the consumer is interested in, right? So, I mean, those are diametrically opposed positions. And of course, Reach has already responded to the CMS's guideline and said, look, guys, that was going to put thousands of small players out of business. Again, force consolidation and require that only the big boys survive, which is bad for consumers, it's bad for the industry. The FCC's proposal is even further, right? CMS kind of looks like a middle ground once you look at the public knowledge position.
Right.
And, it wouldn't shock me at all if some consumer groups come forward and say, hey, the CMS guidelines are going to say you can't sell a lead, to an intermediary, rather than say that consumers have to go direct to a service provider. Why not adopt the CMS guidelines as the middle ground? In fact, I expect that will be the competing middle ground that consumer groups posit, as opposed to the Reach middle ground.
Okay, so and again, going back to the question of consent, and this is just another question that came up: is there some proposed loophole that could exist where a consumer could give explicit consent to sell their information to aggregators for sales calls multi-vertical? I didn't read anything thus far that said that, so I don't know if that's something that would come out of comments that people could draft. But I mean, again, I think that is opposite of the intent here. They're looking to intentionally shut down multi-vertical lead selling. At least that's my opinion.
It's not just multi-vertical. No, Isaac, you're exactly right. I mean, so I understand the instinct, right? Well, can we make it just like really clear to the consumer? And hopefully, right, that's the middle ground position, right? That is the Reach standards. It's like, I like to say it's a cigarette warning label for robocalls, right? I mean, the cigarette industry, as you guys know, kills millions of people a year, which is at least arguably even worse than annoying them. So, the fact that cigarettes are continuing to be sold tells me that at least, in America, free enterprise is such that we allow stuff to happen as long as consumers understand and are clearly informed of what is going to happen next, right? You want to smoke this cigarette? Well, you're going to get poisoned and die of cancer. You want to comparison shop? You're going to get some phone calls from people, right? Again, arguably, one's worse than the other. So the Reach standards, if you guys have taken a look at them, have a black and white box with clear letters, right, to the consumer. Dear consumer, by providing your information and clicking this button, you're going to receive robocalls. Like, this is going to happen because truthfully, a good amount of, look, there's a number of problems that have led to the robocall epidemic. We've already talked about fraud, and we've already talked about abusive practices by lead sellers. But another problem is that consumers are either not reading the fine print or don't get it, right? They're not informed. And so many consumers will tell you, right, with their hand on a stack of Bibles, I did not consent. But then when you look at the actual evidence, they did go on the website and they just didn't realize what they were doing when they clicked that button. So I think the Reach standards in any middle ground position that the industry is going to have to live by once the FCC issues its NPRM is going to make sure that consumers are transparently informed, cigarette warning label style, that by clicking a button, they're going to be getting some phone calls.
And it's funny when you bring up the cigarette label warning, whatever is speaking, and I don't know if I should be proud of this or not, but speaking as a former smoker, I guess I'm proud of the former part. You buy that pack of cigarettes and you'd say, yeah, I don't care if I get cancer. But then the reality is a lot of people got cancer, and then there are all kinds of lawsuits against big tobacco and things like that for, oh, I didn't know that I was going to get diseases, even though it's said it for the last, 30 years or whatever. So, is there still going to be, or we see a lot of private right of action tied into this, to the enforcement of this?
Good. So what I'm hoping to happen, right? Because look, all of this is a balance, and that's something to keep in mind. The FCC is not a consumer protection organization. At least it's not supposed to be, right? The FCC's mission is to protect the telecommunications infrastructure in this nation. This proposed ruling, I don't think it necessarily does that, because it makes it more difficult to access the telecommunications platform, which is not necessarily what you want to have when you're looking at free communication over the network. The point is, what I'm hoping as part of the balance is that if industry does what industry probably should have done a while ago, we're going to talk about too little too late here in a second, and does abide by these strict reach standards or whatever other standards end up being the middle ground position, that in exchange for that, the commission will give a nice limited safe harbor that says, if you buy a lead, or if you sell a lead and these parameters are met and the consumer is provided this level of information and there's fraud detection running on the website and you've got a trusted form and it's nice and clean and it's sent over and the certificate is actually purchased, right? By the lead buyer and everything is nice and clean, that company should be protected from these frivolous lawsuits, which are also out there. And I've been picking on the lead gen industry because, from a certain perspective, we brought this upon ourselves, and I'm including myself in there, even though I don't make these phone calls. But we also know that there's another problem right there, which is, these exploitative litigators who know that there's a bunch of bad stuff going on in the industry. So they go out there and they exploit that, right? They fill out their name on all these forums and like, hey, it wasn't me. Geez, you guys have to get your act together, you fraudulent lead sellers. So it's this ridiculous scenario where there is a lot of fraud, and then you've got litigators going out there creating lawsuits and then being like, oh, look, I'm a victim of the fraud. It's nuts, man. It's the grossest ecosystem on both sides. And obviously good companies that are just trying to buy leads, just trying to talk with interested consumers who actually just want to hear about their product, right? They've got to dodge these shady players on the one hand and these terrible litigators on the other. And it really is unfortunate.
Yeah, and as somebody who's worked in contact centers for over 15 years, I can say that, obviously you need to make sure you're complying with all the federal, state do not call lists, making sure you're checking everything off. Any scrubbing services such as the one that we offer, where you can try to weed out potential professional litigators, those professional plaintiffs, I'd recommend you highly take that into consideration.
Absolutely. People have to protect themselves from fraud on both sides. You have to protect yourself from fraud. I talked, Rich Kahn at Anura is going to be on the board of Reach. I love that guy, and I'm betting heavy on him. I'm betting heavy on technology like his. And I'm going to talk to the commission. Just understand, guys, I will literally be talking to the FCC saying you should require fraud detection as a condition of allowing the lead generators to continue to survive. All right. That's where we are. So just understand that. Right. We're not going to, when we get past this NPRM, it's not going to be business as usual. It's not going to be the world that we're living in today. It's going to be a different lead gen world. It's going to be a much cleaner lead gen world.
And I know a lot of people have poked fun at self-regulation and things like that, but there's a lot of frameworks out there already that exist that are industry specific. But you look at certain things, even like PCI or ISO 27001 or things like that, the companies can subscribe to some sort of standard of good practices for their organization and ethics. I think that having something in the lead gen space, in the contact center space, that we put in front of lawmakers and say, hey, these things exist, these things are out there. You could have ethical companies trying to do ethical things and trying to make consumers aware. I think that if, as an industry, we can make a unified showing that we want to protect consumers, I think it'll work more in our favor than just saying, hey, no, stupid regulator, we don't like that you're giving us more rules. I think if we can show as an industry we're trying to do the right thing, it'll help our case.
It's absolutely critical. And let me say this, in my opinion, and I truly believe this, the industry self-regulation is always superior to government regulation when it is done properly, because the industry understands itself better than the government ever will. The folks that are involved in the lead generation industry know it inside out. They know it better than me, right? They know it inside out, left, right, and sideways. They know all the nooks and crannies. They know what's right. They know what's wrong. It's just a matter of getting these participants to say, okay, look, we know what's wrong, and we're going to do what's right from now on. And when the financial incentives have just not aligned, right, is the problem. And this is something I'm going to talk with the commission about as well, is the incentives, right? The direct-to-consumer marketer, right, the Mutual of Omaha, since I picked on them earlier, of the world, they have every incentive to only call people who are interested in receiving their phone calls and only buying legitimate leads because the TCPA says so. They have no incentive to be cold calling people that don't want to hear from them, because the risk of the TCPA is so much higher than the potential benefit of a cold call to a nobody could possibly benefit, right? So they want to comply. But the lead sellers, right? These guys there's no downside for them because they're not in the line of sight of the litigation. They're not in line of sight of regulatory action. They've been hidden for a dozen years. In fact, they probably only come to light because the FCC reached TCPA World. No, I'm kidding, but maybe not. I don't know. I mean, I definitely think I've had a role, in helping to clean up this industry. And maybe part of that is bringing in the scrutiny of the FCC, which is not necessarily what I was trying to do, but at the same time, it had to happen. So, if that's what happened, then that's what happened. But the bottom line is, to date, the lead gen industry has been largely out of sight. And even though they're not out of mind, because they're the ones that are stirring up all the trouble. And the good guys, right, the lead buyers, my clients, are the ones who are getting hammered in court because of these guys. Well, we weren't going to let that happen forever. So here we are. But at the end of the day, I do believe, as much as I pick on the lead gen industry for the trouble that they've stirred up, I believe in it. I do believe that it is a valuable industry and that it is possible and it is preferable that they regulate themselves according to strict standards that everyone follows, and hence the REACH standards. That's why I created REACH. That is literally why I created it, to stop 500 million robocalls a month, because I know the industry can do it. The government can't do it. The government has failed over and over and over for the last 10 years. The government has failed to stop robocalls. They have flat failed, but the industry can do it. They have to have the desire to do it, and hopefully now they will.
Couldn't agree with that more. And that's such a powerful statement. That might be a place we want to start wrapping this up. We are at the top of our hour. This is a big topic. I would like to get one more question out there, because I've seen this question asked a lot. A lot of people have been asking, is there any implication on anybody acting as an agent on behalf of their clients? So I'm going to take that as probably specifically a BPO type organization or something like that. That should still be safe here because they're operating on behalf of the company that obtained that consent, correct? Or do you think that's at risk?
Well, I'm not sure what the call of that question is. It might be a personal liability question too. I'm not necessarily sure kind of what they're driving at, but if you're talking about a true employee of a company, and the employee is receiving consent, then that is consent to the company, right? As long as all the disclosures are made. If you're talking about a downstream agency in the sense of an agent of a mothership, an agent that sells, Allstate or something, it should be the same rule as long as it's an exclusive agency relationship of that sort. And then from a personal liability standpoint, yeah, I mean, the potential exposure that you will be facing is going to track the new rules. So it would definitely expand the risk for personal liability as well. I'm just not sure what the question really is.
Well, so and I'm trying to shorten this and combine a whole bunch of different people asking, but as I'm understanding it, let's stick with Allstate. So I'm Allstate. I get consent on a lead on my website. Everything's legitimate, real person, all of that. But as Allstate, I've decided, I'm great at insurance products. I'm not great at customer communication, and I'm not speaking for Allstate there. I'm going to outsource this to another company to handle my voice communication. So I hire BPO XYZ. They place that phone call on behalf of Allstate to present themselves as an Allstate representative. Okay, and that was my understanding as well.
Yeah, the issue here is Allstate getting consent in the first instance. The issue is not the means by which Allstate makes communication with the customer.
Okay. All right. Well, any closing thoughts before I wrap this up?
Look, I think we've really said it and beat the horse to death. You know, the commission is definitely going to be adopting some new rules. This is definitely a watershed event. You know, it's going to be, you know, 10 years from now or 4 years from now, 5 years from now, we'll be talking about the pre-NPRM and post-NPRM in the you know, lead generation world. It's going to be a different world. Hopefully the commission will, you know, hopefully industry will heed the call, get out there, talk with commission, you know, make sure the commission understands that there is value to this industry. There are players that want to do it the right way. You know, I hope that everyone will, as appropriate, fall on the sword and say, you know what, industry should have done more. They should have done more for a while, and they haven't. But this is not too little, too late, right? You know, Reach got there first, right? Reach was ahead of the NPRM. So if we're too little, then the government's too little or too late, then the government's too late too. And our proposal is not too little. I don't believe. I believe there is a lot of meat. You know, stopping pre-recorded calls to consumers as a first contact, limiting the number of times a lead can be sold, destroying multi-vertical leads. You know, we did that before the commission proposed it. So, you know, and again, Reach is just one organization. There are others as well. So I definitely encourage all of you to be active, educate yourselves, read about this, because if this is important to your industry, if this is important to your livelihood, it matters. It matters right now. What you do next matters.
All right. Well, thank you for that. And guys, you know, there's been a lot going on in this call, and obviously this is going to be developing. So we're going to be trying to provide information to you as soon as we get it. You know, we've got our contact information up here on the screen over at Contact Center Compliance. So we'd love to hear from you if you'd like to have any follow-ups. Obviously, I don't have Eric's information up here, but TCPAworld.com is a great place to go. And you get there and sign up for the blog, and you'll have all kinds of contact information if you have anything for him. We're also both going to be speaking at LeadsCon in 2 weeks in Las Vegas, as Eric was at the beginning of this. So we'd love to see you there. We'll have a booth at Contact Center Compliance. Eric's more of a mingler from what I've seen at the shows I've been at with him, but you'll definitely be able to recognize him. So, you know, please stop by, have a drink. Let's talk compliance. Let's talk lead gen, contact center. Let's talk about anything you'd like. But thank you all for coming. Anybody whose questions we didn't get to, we'll do our best to get to those in the next couple of days. And this video should be available at dnc.com/webinars shortly. So thank you for coming on this webinar, and everybody have a great day.
Thanks, everybody.